All right, picking up from where we left off. All right. Last we left off, we were talking about invalid and unlawful warrants. A warrant must have certain requisites in order to render it valid and available as a defense. Many unlawful arrests have been made due to warrants failing to meet such requisites. When a warrant is invalid on its face, or where it is only a summons, the officer arresting defendant will be liable in damages. A prima facie invalid warrant will be regarded as no warrant, and the officer making the arrest by a void or invalid warrant is not protected by it. Process that is void on its face is no protection to the officer who executes it. If a warrant, order, or writ of possession shows lack of jurisdiction of the court, the officer is not protected in serving it. In fact, in so doing, he becomes a trespasser or a wrongdoer, okay? A constable justifying, and when we use words like trespass, wrongdoer, this is the common law, all right? A constable justifying an imprisonment under a warrant must show that the warrant on its face is legal and that the magistrate had jurisdiction of the subject matter. Now, how many sheriffs and police officers do you know that know a fucking thing about jurisdiction? I can be real honest with you. I don't think I've encountered any of them. And I've encountered some pretty high-ranking officials throughout communities, and I don't think many of them even understand what fucking jurisdiction is. You know what they do? They say, well, I'll have to talk to the lawyer about that. I have to go talk to the prosecuting attorney about that. You think the prosecuting attorney is going to argue with the judge? No, not happening. Okay? They're in business together. And let me tell you something. Business is fucking good when you're wearing fucking sheep's clothing and you're the wolf, all right? Both a proper subject matter jurisdiction and geographical jurisdiction are necessary for a valid warrant. It is generally held that where the court has no jurisdiction, the officer executing a warrant will be liable in damages. So, you know, for all you agents and agency out there that think that these lawyers have your best interest at heart, I'm telling you, they're selling you down the river just the same as they're selling everybody else down the river, because their system of justice is just about us, just us. It's about them, not you. And you're not a participating member in the bar. They have no interest in really protecting you other than the fact that you feed them, okay? And the wolf doesn't so often bite the hand that feeds. They put you out there amongst your fellow brothers and sisters to rein in your family members, friends, and fellow people in the community so they can fleece everybody. But when push comes to shove, make no fucking mistake about it. If the warrant is defective, guess who gets sold down the river? You, as the agent executing the warrant, gets sold downriver. Not the judge, not the prosecutor, nobody else, you. So it may behoove you to pay attention to what the fuck I'm telling you. It is generally held that where the court has no jurisdiction, the officer executing a warrant will be liable in damages, because you had a duty to know your job. Not ask the prosecutor, not ask the judge. You had a duty to know this. You had a duty to know about jurisdiction, which I don't think you guys are taught in police academy training. I have never heard any officer that I've talked to that's went through the police academy training exposition or exposés ever say, oh, it's about jurisdiction, or even talk about jurisdiction. They just say, hey, look, we do what the statutes provide. The lawyers taught us, you know, our instructors who were instructed by lawyers told us this is what we are to enforce. So you do what you're told, but you don't research any further into your actual rights, duties, titles, and obligations? That doesn't sound right, okay? It is generally held that where the court has no jurisdiction, the officer executing a warrant will be liable in damages. The question of jurisdiction can be raised at any time, and since neither consent nor waiver can give jurisdiction, the court will not proceed where it appears from the record that it has no authority. A warrant for the arrest of an alleged fugitive was void because the complaint did not state that the original charge has been made upon oath or made to a court, and if afforded no protection to the constable. The requirements, and what they're talking about there is the affidavit in support to support the probable cause for a warrant to be issued, which means some man or woman aggrieved is claiming a harm, damage, or loss. Not that some agent and agency is saying a statute was violated, because that's benign. First of all, statutes, codes, city ordinances, rules, and regulations are intentionally written vague and ambiguously, okay? And if they're vague and ambiguous, that means they're open to interpretation, so no agent and agency can be a witness and a process server at the same time. You're either the witness or you're the process server. And if you're the witness, who's the fucking victim? The state can't be a victim, all right? So when you're doing these probable cause affidavits based upon what you've heard, first of all, that's hearsay, okay? Falsifying a record based upon what somebody else has told you, but not getting an affidavit from them, not investigating further and getting any witness statements, looks awfully fucking fishy. The requirements of what a warrant should contain depends primarily on constitutional mandates, due process practices, and common law principles. The common law requires that an arrest made on a warrant be issued only after a formal charge is made under oath. Thus, no arrest is valid unless based upon sworn affidavit, meaning that I'm willing to face 1 year in jail, a $10,000 fine, if it is found to be contrary, the information that I'm providing. I'm pledging the eternal damnation of my soul, knowing that I am bearing witness against somebody else under sworn affidavit, okay? So a sworn affidavit is not based upon hearsay. It's based upon the first-hand knowledge and facts that you have. Now, a lot of these affidavits from agents and agency, they're always hearsay. Nancy told me that so-and-so, kicked her trash can and then she showed me the trash can and I looked at the trash can was knocked over and Nancy said John Smith did it. Well, wait a minute. How did Nancy see John Smith? Does she have any photo evidence of it? Was there other witnesses? Because other than that, it's just he said, she said thing. She says he did it. He says he didn't. There's really nothing for me to go off of. I can't go arrest the guy. I can put together what you said, and you can put it together in an affidavit, but everything that you told me is nothing more than hearsay. So when I write it down on an affidavit and try and get a probable cause warrant issued for that without having any of your the woman or the man's firsthand knowledge and experience written down on an affidavit, it's nothing. It's bullshit. An affidavit that does not appear to have been sworn before any judicial officer and a warrant signed only. And here's another thing. When you sign an affidavit, that affidavit needs to be notarized. You need to notarize that affidavit, and that way it can be authenticated at the Secretary of State's office and be utilized as evidence in the hearing. Otherwise, an affidavit, until being deposed, is nothing more than hearsay. That's the honest to God's truth about it. Anybody can swear out an affidavit, but until you're deposed on the context of the affidavit, that's nothing more than hearsay. A lot of these people run around saying affidavit, if unrebutted, is true in fact in law. No, it's the presumption and assumption that because nobody rebutted it, it's true in fact. However, until you're deposed, it's really nothing more than hearsay. An affidavit that does not appear to have been sworn before any judicial officer and a warrant signed only by the officer who made the arrest and not dated or authenticated, afford no lawful authority for the arrest and detention of an accused. Another obvious requirement of a warrant that would make it void on its face is if it is not signed by the magistrate. Now, signed by the magistrate or the justice of the peace. Now, under Federal Rule Civil Procedure, Rule 17, they must use their full legal name, first, middle, and last. It's also upheld under Title 18, 1341, 1342, frauds and swindles under false and fictitious names. False and fictitious names is, let's just say I use Derek S. Gonzalez. That's not a full legal name. We want to fix full commercial and personal liability of these people. They need to use their full legal name. The warrant can be defective for failure to use their full legal name. We would move to have sanctions put upon them for not following their own mandates, okay? Under Federal Rule Civil Procedure 17B, I think it is, 17B, full legal name. It has become a practice in some areas to have warrants rubber stamped with the judge's name, okay? Rubber stamps don't fucking count, pal. All right, anybody could do it. You don't have to recognize it. You don't have to acknowledge it. That's a rubber stamp. Get the fuck off my property. Have a nice day. When you actually have somebody who's going to assume full commercial and personal liability, you come on back here, all right? When they're ready to put their money where their fucking mouth is, then you can come over here and grab me up. But until that point, fuck off. This stamping being done by some clerk or administrative employee. Now, most clerk of the courts, okay, they never went to law school. Okay, they don't have a JD in law, all right? How are clerks making legal determinations, all right? That's technically in their world is practicing law without a license. Shame, shame, shame. Gonna have to notify the Bar Association so they can move sanctions against you for practicing the unauthorized practice of law, okay, and violating your oath of office. Administrative employees, I don't know what they mean by that in a generic sense, but let's just say the clerk of the court has underling underneath her, and they consider that an administrative employee. I don't know. It's pretty vague and ambiguous again. This blatantly unlawful practice has been adopted for convenience sake because nobody wants to wake the judge up at 3 a.m. for bullshit, right? Because the judge is going to get awfully pissed off. You keep waking them up at 3 a.m. for frivolous nonsense that they can't put their name on. Which is the most common reason or excuse government uses to transcend constitutional limitations. They're passing the liability, kind of like passing the Buck Act. Judges going, yeah, well, you can use it, but if you get caught, Cindy Lou, I'm not going to say that I authorized you or granted you power of attorney to rubber stamp any fucking warrants. You realize you go down the river too, along with the sheriff and everybody else, because I'm not going to lose my fucking pension and my $280,000 a year job and my retiring as a millionaire based upon the fact that you rubber stamp shit. And when you tell everybody that I told you you could, sure you can, just like you can jump off a 10 fucking story building. But I didn't give you any legal advice, and I didn't authorize you, and I didn't give you a power of attorney, and I didn't give you an assignment to utilize my name in any way, shape, or form. So guess what, Cindy Lou? Your ass goes to jail too. Such limitations, and the judge will walk. The judge will absolutely fucking walk, whistling Dixie. Such limitations were designed to make government follow certain established procedures and thus make things difficult in order to deprive a citizen of his liberty or property. A rubber stamped warrant is invalid on its face as it is not signed by any judicial officer. The authorization for a warrant requires not only judicial authority, but it is to be done by one who is learned in the law. Does the clerk of the court constitute somebody who is learned in the law? I don't think so. To determine if probable cause exists to issue the warrant. Now, if the clerk of the court rubber stamps this motherfucking warrant, and she's supposedly learned in law, okay, then she assumes a full commercial and personal liability for trespass against you, violating your unalienable rights by denial of due process of law. She is not authorized to make legal determinations. Okay? In Minnesota, the state Supreme Court held that the statute permitting clerks and deputy clerks of the county municipal court to receive complaints and issue warrants in prosecutions under municipal ordinances is what? Unconstitutional. The court said the United States Supreme Court has considered and disposed of a related problem in Karma versus Municipal Court 387 U.S. 523, 541. The majority in Karma nevertheless stressed the need for individualized review by a neutral magistrate to avoid the issuance of rubber stamp warrants. Since the taking of an affidavit in a criminal proceeding imposes a duty of a judicial nature, an affidavit taken before a clerk or prosecuting attorney is not sufficient as a basis for the issuance of a warrant is regarded as insufficient and thus void if, on its face, it fails to state the facts sufficient to constitute a crime, okay? Also, a designation or description of the offense should be written in the warrant, but need not be specified with the same technical strictness that is required in an indictment. The rule on sufficiency of a charge on which a warrant can issue is stated as follows. The complaint or charge on which a warrant is issued must set forth the facts constituting the offense on the knowledge of the person making the complaint. The first-hand knowledge, the one who actually saw it, okay, or was directly affected by it. And if he does not know them, other witnesses must be examined who do know them, and no person can be arrested on the mere belief of the person making the complaint, which means there's got to be somebody else that supports it, or some form of evidence that supports what they're saying. A warrant issued for a matter that is not a criminal offense is no justification for a constable who arrests upon it. A person cannot be lawfully arrested by a sheriff acting under a copy of a court order or warrant in the form required. Such copy is not valid. Why? Because a copy is nothing more than a forgery. And in the 21st century, everybody can make copies of all kinds of things. They can copy the judge's signature, transpose it onto a document, allege that it's a warrant, and there's got to be a way of validation, and the only way of validation is a true wet ink signature, full fucking legal name, assuming full commercial and personal liability, all right? Stating the facts with the attached affidavit in tote. Inaccuracies and imperfections do not vitiate a warrant which substantially charges an offense, but with a complaint recited in substance in a warrant is verified merely on information and belief and does not state facts sufficient to constitute an offense, the warrant must be held to be invalid on its face. Now, this key word in here is information. Information is not factual. Information, in its broadest scope, is nothing more than a belief or hearsay. The information being provided has not been verified yet. It has not been validated yet, okay? So we're leaning on the law here. The warrant must be held to be invalid on its face. Also, an affidavit that merely states belief, all right, let's talk about this. I believe, I suspect, I think, there's a number of others. You can just start out with those, type them into Google, and they'll give you all the synonyms for it, you know. So anytime somebody says in an affidavit, I believe, I think, I suspect, I hypothecate, it seemed like, those are all frivolous fucking statements, okay? That's all about belief, and belief is not a fact. Actually, belief is actually the lack of fucking knowledge in the guilt of the accused is sufficient to support a warrant of arrest. The Supreme Court of Kansas said that a warrant cannot be issued which is verified on the county attorney's hearsay and belief. If a warrant in the first instance may issue upon mere hearsay or belief, then all the guards of the common law and of the Bill of Rights to protect the liberty and the property of the citizens against arbitrary power are swept away. An affidavit based on a presumption or a belief of a crime does not give jurisdiction to the court to issue a warrant. And at common law, a constable or a sheriff cannot execute a warrant outside their jurisdiction. To summarize, the following are the basic requisites needed to make a valid warrant. A warrant is to be issued by a judicial officer and signed by him or her. It must state the facts that show the matter to be within the jurisdiction of the judicial officer issuing it. It cannot be based on belief or suspicion, but upon probable cause. The warrant is to list a complaint, which is to state the offense committed and the facts that constitute a crime. A warrant is to be supported by a signed affidavit and made under oath by the person making the charge. It must truly name the person to be arrested, full legal name, or describe him sufficiently to identify him. The warrant must also command that the defendant be arrested and brought before the nearest available magistrate. The officer is bound to know if under the law the warrant is defective and not fair on its face, and he is liable as a trespasser, a wrongdoer, if it does not appear on its face to be a lawful warrant. His ignorance is no excuse. The typical form of a warrant is like this. Municipal Court, Springfield Judicial District, to any peace officer of the realm of jurisdiction, upon signed oath having been brought before me that the crime of larceny has been committed, and accusing John Smith of the same, you are hereby commanded forthwith to arrest and bring that person before me. Bail may be admitted in the sum of $1,000, dated 15th May 1997, /S/Bill Wright, presiding judge. All right. Every citizen should, when arrested or at trial, request to see a warrant and check that it meets required criteria, and object if it does not. Point out that the arrest is unlawful and how a warrant is defective. Such vigilance is necessary to secure liberty and to stop unlawful and oppressive measures from continuing in government. When we come back, we're going to get to one of my favorites. Bringing arrested persons before a magistrate. All right, and this is the duty of every arresting officer. I don't give a shit what they fucking tell you about. We got 72 hours. We can hold you for indefinitely under the National Defense Authorization Act. We can do whatever the fuck we want. I'm going to tell you the law tonight. I'm going to give it to you, and you do with it what you will. All right, but when we come back, we're going to be talking about bringing arrested persons before a magistrate. Remember, you are not to be denied life, liberty, the pursuit of happiness, property, without due process of law. And one of those safeguards is when you're accosted against your will, you are to immediately be taken to the nearest magistrate. And I don't give a fuck if it's 3 a.m. and they got to wake them up and drag their ass down there out of their fucking beds. That's what it is, all right? So, with that said, we'll be back here in just a little bit.